Welcome to the Safety and Risk Success podcast with me, Christian Harris. And we're back after a bit of a hiatus, and I apologise for that. There's been a huge amount going on behind the scenes with me and the business, all of which is really positive, but it's just led to a bit of a lack of time to be running webinars such as the Safety Roundtable and the podcast. But I'm pleased to say that we will now be back on our regular schedule because we've made lots of improvements, added to the team, and done lots of other things to enable us to continue producing content such as this for you. So we're back with a bang too, because I'm really pleased to share this recording of a safety roundtable we ran a couple of months ago now with Kizzy Augustin. And Kizzy is a well-known health and safety lawyer. She advises leading businesses on how to deal with health and safety related issues, including insurance claims. And she is going to share with us today a safety legal update. Now, Kizzy's going to run through the update, things that have been going on, the trends, insights, and so on. I chip in and ask lots of good and insightful, hopefully, questions. And then we have a few questions as well from the panel. There are some slides to accompany this. So if you're on the podcast version, you can find those in the show notes, and I'll also put the show notes for the YouTube as well. So I hope you enjoy this episode with myself and Kizzy Augustin giving a safety legal update, and look forward from now on to be back on a more regular schedule with you. Cheers.
Welcome to the Safety and Risk Success podcast with Christian Harris. We believe that proactive safety and risk management powers business performance. Each week we explore this theme, sharing guests, stories, insights, trends, hints and tips. You can find us on all the major podcasting platforms, and video versions are available on YouTube. But for now, let's join the conversation with Christian.
Good stuff. Well, thank you, everybody, for joining. I'll carry on letting people in as we go. But it's great to see you here for this safety roundtable. And we're going to be talking about the law and giving a bit of a legal update. So serious topic today with a very serious panel of myself and Kizzy, who I'm delighted is joining us. I've known Kizzy for a number of years. And she does a lot of these kinds of events, so as well as her day job of actually doing this stuff as well. So looking forward to her sharing her insights with us. And the structure for today, Kizzy's going to do a bit of a presentation for us, and then I'm going to ask her a few questions. And then, as always on these sessions, we'll open it up to a bit of a Q&A. And give you the opportunity to ask Kizzy questions. What I would say is, and I'm going to just stop sharing for now, what I would say is she's not here to give you free legal advice, so don't ask any too specific questions, but broader questions about principles and things like that are fine. We don't want to have to send anybody an invoice after this session, do we?
You'd bulk at the fees, but
exactly, yeah, exactly. So I've got this problem and this and that's happened and this and that, and what should I do about it? We'll try and avoid questions like that, but more broad questions are absolutely fine. So with that, then, Kizzy, welcome. Thank you for joining, and I'll hand over to you, and you can give us a bit of a safety legal update.
Okay, let me try and share my screen, and hopefully this is actually going to work. Oh, I hope so.
Fingers crossed.
And you can tell me what you can see.
Looks good.
Right, can you see slides? If I go to this one, if it does it, I kind of want you to see the one slide. Right, what can you see now?
So I'm still seeing the sort of the left-hand side is showing all of the slides, and the right-hand side is showing
seeing the right one.
Not seeing the full screen.
Let me make sure you're seeing the right one. PowerPoint slideshow, maybe it's that one. Okay, now tell me what you can see.
Perfect.
Can you see
one slide?
One slide.
Yep.
Yep. Okay, let's make sure that can move. Yes, that moves okay. Yeah, do you see the next slide here?
Yep.
Right, brilliant. Okay,
Perfect.
so all right, I've been asked to give a legal update, but I suppose this will be less of a kind of legal update to bring us where we are, and more of a hopefully reminder of the health and safety sentencing guidelines and what they mean. And I know the audience is fairly broad, so I'm hoping I'm not going to put anyone at a disadvantage if I repeat some of the things that perhaps you already know. But one of the things I wanted to touch upon is what these guidelines are and where we are sort of 7 years later, but also just to bring into play some of the cases that have come about in the UK and how they demonstrate the application of the guidelines and what they mean, but ultimately what they mean for the likes of the companies that you work for, companies that you might advise, and the individuals within both. So I hope that's going to be helpful. I'm going to try and whistle through quite a lot of this because I do hope some of this is really a refresher, and I do want you guys to have an opportunity, and Christian, to have an opportunity to ask questions, of which I hope I can answer all of them. So by way of reminder, we are essentially dealing with corporates and individuals and the duties within both. By way of corporate responsibility, obviously our overarching act is the Health and Safety at Work Act, but there are a number of other regulations that we concern ourselves with each day that also impart duties on corporate entities and individuals. One of which, as we can see here, the Health and Safety at Work Act, Section 2, 3 and 4, all dealing with this duty to look after the health and safety and welfare of employees, health and safety of non-employees, and if you're not an employer, but you have to any extent control over premises or a site, then you have a responsibility to ensure access and egress to that building or site is safe, and any plant or substance that's used is done safely and without risks to health. Obviously caveated by the phrase so far is as reasonably practicable, so you do not have to do everything that is possible to achieve compliance with those sections, but it's doing what is reasonably practicable in the circumstances, which is essentially cost benefit analysis. Doesn't stop there, because we do have to worry about our individuals as well, and it isn't just directors, as we will come to see. We all of us have this responsibility to look after ourselves and each other. It's this duty to take reasonable care of us, but others who are affected by our work activities, and that's generally our colleagues. I think we all do that anyway. But it's the senior manager director offence, which is the one that keeps people up at night, and that's the ones that where you see the cases being made a lot of, where an offence has been committed with the consent, connivance, or attributable to the neglect of a senior individual, whether that is a director, manager, company secretary. I say someone who has some form of influence over the activities that that business performs. So you don't have to be named a director, but it really is about what you do. That person, as well as the company, will be guilty of a health and safety offence, and that's the Section 37 offences, which is what we see very often, directors being hauled up in front of the courts and being made examples of because they have done something actively or failed to do something in the capacity as a senior individual within the company. So we get to the guidelines. That we've had these guidelines now for 7 years. I think for a moment in time, we thought, oh, the impact is going to be huge. And then we saw some of the sentences being imposed, and then we weren't quite sure. Then the HSE or Sentencing Guidelines Council carried out an impact assessment of the guidelines, and we kind of saw it was effective. It was acting as a deterrent. Awareness of the guidelines was pretty clear. But what we haven't yet seen, and I think is a real issue, is total consistency with the way in which the courts are applying the guidelines. And that's not only in respect of health and safety matters, but it's also in respect of other safety matters. So yesterday, someone mentioned to me about developments in building safety and whether or not we are going to see a new set of guidelines for fire safety offences, because these guidelines don't strictly apply to fire safety, because fire authorities felt that they had enough that dealt with the seriousness of fire safety. And in fact, there's a bit of a conflict because of the nature of fire safety offences, talking about risk of serious injury or death. I mean, the risk is almost always going to be a very high level of risk. So it would be a disparate amount of sentences given in respect of fire safety. There may well be new guidelines. I don't know. Ultimately, what happens here is for most fire safety cases that are of a serious nature, the courts are asked to take these guidelines into account. So that's what we've been seeing in reality. But the reason I just want to touch on what the guidelines actually say is because I think there are 3 areas in which individuals of businesses can have some influence over. One of which is the culpability level. So you have an incident, it's really about how culpable the company is and individuals concerned, but how culpable they are, how far short of the standard expected of this particular company or this particular industry have you fallen far short of. So it's that level of culpability that's an issue. And again, another observation is that most cases are likely to fall in the high category, because prosecutors, when they bring their cases, often say the reason we are prosecuting is because this company has fallen far short of the appropriate standard. So it's
when I
difficult.
spoke to, I've spoken to, EHOs in councils about this before, and they've sort of always said, well, if we don't think it's high, then it's not going to get that far, is it, that we're going to be prosecuting?
There you go. So it's a real disadvantage, I think, for companies who are finding themselves up in the dock, having to climb down from that very high bar that's been set by the prosecution, which will convince a judge, because why wouldn't they? If the prosecution are prosecuting because of that, then perhaps that's where we should start. So it's a first disadvantage for any company. Second step is figuring out the harm category. And you can see here level A, level B, level C. Hopefully all of you have seen this before. But for those of you, again, who perhaps aren't familiar with the guidelines, level A is, and we're talking about risk here. So we're talking about seriousness of harm, risk, not what actually happens. And you'll probably see the second disadvantage, because for it to be a level A offence, it's likely the harm risked is death or physical or mental impairment that could result in lifelong dependency. It's very hard to see a simple health and safety case that couldn't potentially fall in that category. Most cases could potentially result in death or serious injury.
Indeed,
So it's I think it's a second disadvantage to companies, that you're almost always going to start off in the level A. So high culpability, level A. What helps with this category of harm is the likelihood of that risk occurring. So while you might have to accept, particularly as a company, that it could result in death or could result in a mental or physical impairment of this nature, what you'd argue is the likelihood of that actually occurring is lower than what you think, Madam or Mr. Prosecutor, because we've got good measures in place, or we have engaged with our workforce, or we instruct competent contractors, or whatever it is, you will argue your case to bring the likelihood down as low as possible.
My area of slips is a classic example here, because people do die from slips. There's been a prosecution of the co-op after someone died when they slipped in a store and banged their head and passed away. People can die, but obviously the likelihood of someone dying is remote, you would say.
And that would take you, I mean, even on that case, that would take you then to harm category 3, if we accept level A death, but likelihood of it occurring remote. Now, you might think that's where things stop, but unfortunately, that isn't the end result, because yes, we are talking about the risk of harm here, but there is an opportunity for a judge to go up a harm category. So we're talking here about harm categories 1 to 4. We have just argued your slipping case, akin to the co-op case, could potentially be harm category 3. I'm sure the prosecution might argue in this particular case it's harm category 1 or 2. Let's say you settle in the middle on harm category 2. And then you think, that's it, we go ahead, we get sentenced. What next? Well, the judge has the opportunity to go up a harm category, or at least up in the range of the category that's been chosen, if there are one of two things happening. You've exposed more than one worker or one member of the public to risk. Again, most cases you could potentially expose more than one person, or there has been some actual harm. So someone slipped and actually hit their head, they've suffered actual harm and not just the risk of harm. And as a result of that, the judge can go up a harm category or up to the top of that range, which will make a massive difference in terms of the financial penalty imposed for companies. And then the third thing to look at is the means of the company, so financial position of the company, and that goes from micro all the way to large being a company with a turnover of 50 million or more. If you're talking about very large companies, I can't tell you exactly what that might mean in terms of the level of turnover, but the definition is very greatly exceeds 50 million. We have had cases that talk about turnovers in the hundreds of millions. We've had companies that are in the billions and still haven't been dealt with as a very large organization. What does it mean though? To be a very large organization, if you are in that category, it just means there's no matrix that the judge has to apply when it comes to starting points of a fine and the range of a fine. The judge can choose a figure of their choosing, which is quite dangerous actually. So what do the fines look like? Well, they look like this for large organizations. Again, many of you will have seen this, but even in that little scenario that we kind of made up, Christian, we were on high culpability and harm category 2 if we were lucky to be in agreement with the prosecution and have that accepted. Starting point of that nature, starting point fine of an offence of that nature would be a £1.1 million fine, which is quite huge. Now that in the co-op case, it was a fatality, but it might go up or down depending on your aggravating or mitigating features. So if you've got lots of good things to say about the company, then you could bring a fine of that nature down to 550,000, or it could go up if there are aggravating features that place you in a kind of exacerbated situation, all the way up to 2.9 million, which is quite difficult. Even for medium-sized companies who have turnovers much lower, but 10 to 50 million, I think the impact actually is felt more by medium companies because they've got less means available to them. So if you go same scenario, high culpability, harm category 2, starting point 450,000, which I think is still quite huge for a company that has a turnover of 10 million. And that's for one charge. That's for one. We're seeing a lot of cases generate a fine of around about £1 million per breach, certainly for large organizations. So we're kind of gauging that as a bit of a benchmark, but that's a lot of money for things that, and for offences that don't always result in fatalities.
Can you put that into a little bit of context from before 2016? So one of the reasons that, as I understood it, that these sentencing guidelines were amended or improved, or whichever way you want to look at it, was that previously you might have a small company like mine, which would be a micro business, or and let's say somebody like a Tesco, which is a very, very large business, and we would have, if we committed the same offence, we may end up being fined the same amount, and it was felt that that was kind of unfair to the smaller business, and it should be that fines would be larger to larger businesses. I think that's the kind of context.
There is, I mean, there's that. In terms of the level of before the sentencing guidelines, I mean, even before that, when I started out in health and safety, we used to use as mitigation and certainly a convincing factor to clients that the maximum fine you're ever going to get for this in the magistrate's court is 20,000. So let's have a go at this, let's challenge. When there was a change in respect of the unlimited fines for either court, it was probably the start of the game changers. So it was no longer going to be, there's a cap on the figure that you could get in terms of a fine as a corporate for a health and safety breach. And then you just judge whether or not you wanted to go to a Crown Court, who were likely to have judges who were more experienced in this sort of work, or hedge your bets with a lay magistrate's bench or a district judge in the lower courts, just as a way of trying to maybe convince those that tribunal that it was a less serious offence and therefore you should get less of a fine. I mean, it's still quite difficult to this day. But one of the reasons, yes, you're right, is that these guidelines came in to give a bit more parity between the types of fines given out to smaller organizations, as opposed to lumping everyone together and just dealing with the breach in itself. But it was also that the regime wasn't commensurate with the way in which other regulatory regimes were compiled, such as frauds, for example. You know, the fraud regime gave out fines in the multi-millions for companies. The environmental sphere then dealt with, in fact, they were the first to have these guidelines in place and deal with breaches of environmental law in a very significant and serious way. So it just felt like the health and safety regime should be dealt with in exactly the same format, and we should have more significant fines to represent the seriousness of risk that is exposed in these circumstances.
And I seem to remember sort of maybe around 2018 or 2019 that seeing some analysis of 7-figure fines, so £1 million plus fines, and there was kind of an exponential growth in the fines of that level over that previous couple of years compared to before.
And that's remained pretty constant, actually. But it was a huge jump, in 2016 to 2018, where you started to see small fines in tens of thousands, and for the same offence you were getting sort of £1 million fines for the same offence. Crazy, really. So those are the kind of the three things that I think individuals can have some influence over. All of the other things that come out of the guidelines relate to proportionality and whether or not a company's turnover should be used as a benchmark, or should it be the kind of pre-tax profit that's more accurate. Will a fine of this nature put the business out of business? They adjust accordingly for charitable organizations, publicly funded organizations, hospitals, schools, etc. You get a discount because you're able to argue that the impact of £1 million fine, for example, would have a significant impact on the ability to provide services to the public or to service users. And then you get your general third knocked off for a guilty plea. So I mean, these are all encompassed within the guidelines, but it's the first three that really hit home.
How often do people not plead guilty, as it were, and therefore don't get that third fine? So most of the cases that I see, people seem to be, organizations seem to be quite sort of, yes, something's happened terribly badly and we admit there is some liability, and then it's you're bartering over the quantum. But how often do people actually say, no, I'm not guilty, and we want to fight this?
So we had a bit of a graph of kind of challenging, as in not guilties, up. Guidelines came in, guilty pleas. In fact, guilty pleas went up, and not less challenge. And I think we're at a stage now, 7 years later, where I think companies are worried enough about their reputational risk as well as the financial implications that they want to challenge again. Because there's too much at stake. So, the guidelines come in, you start hearing £1 million fines, £1 million fines. We want discounts. We want to just get rid of this. We want to just deal with it. And as you say, companies will say, we've done something, so therefore we should hold our hands up and deal with it that way. I think that's not necessarily a commercially astute way of looking at health and safety compliance. I think, and it's also not necessarily a strict legal way either. I think you have to look at the detail, and you have to look at what is it exactly that the company is said to have done or not done. And it might well be an argument about whether or not the breach is causative of an injury. If we're not talking about risk, it might well be we are the wrong duty holder here. We're not responsible. So actually looking at the detail of what the prosecutions say, I think is quite important. And if there is an opportunity to challenge, there may have been an opportunity to challenge far earlier than the court proceedings. But if you get to court proceedings and there is an opportunity to challenge reasonably without incurring lots of sort of legal costs or expert costs in that regard, then why not do that? And I think companies are familiar with the regime. They're familiar with courtroom drama etiquette, and they deal with that appropriately. And it might well be that there is a way to move forward to challenge and negotiate behind the scenes without having to actively go into court and fight. But if you stand by your policies, your procedures, your reputation, your accreditations, your instruction of contractors and so on, then why not challenge? because that's the only opportunity you're going to get to have nothing at all recorded against the company. And I think worst case scenario, if you do go all the way and you lose, there's still going to be an opportunity to mitigate. Even though you can't mitigate on the basis that you didn't do anything, but you can mitigate on the basis that actually, in the scheme of things, we haven't, you say we've committed a breach, perhaps this is not as bad a breach as you say. We want to qualify that or quantify that or give it context, and then you mitigate and reduce the fine appropriately. So it may not be a third, but you can still get a reduction.
You'd sort of think that logically, and I know this isn't how the law works, but logically, if there's a strong enough case to challenge it, then perhaps that would be deserving of less of a fine than actually somebody who. And I saw a comment actually about this. Is it a bit unfair if somebody's kind of absolutely banged to rights, they've done something terrible, and they plead guilty and get a third off, whereas somebody who actually perhaps it's on the borderline, and they're found to have been guilty. That's an interesting question, isn't it?
It's a very interesting question, and if I answer honestly, the honest answer is the law isn't strictly fair. So I wish it was different, but I think you're absolutely right. Someone could plead guilty, get a third knocked off, and get a fairly reasonable result, as opposed to someone who stands by their conviction that they have done everything reasonably practicable actually to be compliant and to ensure that everybody's safe that needs to be safe, and just have a bad jury on a day who convicts them. Which is very unfortunate, but it's the chance you take. It is a chance you take, but hopefully an informed decision is made based on all of the circumstances, which is why you have experts who help you, you have lawyers who help you, you have consultants who help you make those decisions. I've just given a bit of an outline as to some of the significant fines we've had. A lot of you will recognise some of these cases: Merlin Attractions, Alton Towers, Tesco. I'm going to talk about Tesco a little bit, but only because a nod to the slipping incidents. But Tesco, in one of their cases, in fact, were fined 8 million for an environmental breach that resulted in an oil spill into nearby rivers and streams and affected nearby residents and so on, for 26 hours, I think. So because of that, they were fined, in respect of an environmental breach, 3 million and 5 million for the health and safety breaches. So they've had a number of cases of a similar nature. Network Rail, a level crossing not identified, and a person walked underneath the level crossing and was hit by a train. There's lots of these cases that come up, but these are kind of some of the more significant ones. I wanted to highlight a couple of cases for those of you who perhaps haven't had lots of experience in the courts, but maybe have heard about some of these cases. I've just picked a couple only because I think there are some very interesting points. I'm not going to read out the whole thing because you've got slides. I don't know if you're in a habit of providing slides or anything, Christian, but if anyone's mildly interested, I'm sure I can forward it on. But one of the things that I think is important to look at is this idea of challenge. And this is a case, the J.G. Hale construction case is a case that involves notices being served initially in respect of health and safety concerns. 2 notices were served over a period of 3 days. I think they were complied with and all dealt with. And as far as the company were concerned, yes, there have been an identification of issues, but they've been dealt with. You served us notices and we've complied with them. Thank you very much, HSE inspector. A few months later, they received summonses through the door, suggesting that they were in breach of health and safety and fire safety. And I thought, well, this is a bit unfair. We've already dealt with this and we dealt with it really quickly. And you engaged with us and we complied. The problem is when notices are served, and I say in particular fees for intervention, where the HSE can just turn up at any time and identify material breaches. I think when things like that happen, there's always a risk that in complying with or not challenging notices or paying the invoices from fees for intervention, you are accepting some form of liability in doing that, albeit the financial part of it might be relatively small. Most fees for intervention invoices are about between £500 and £2,000, which is not very much. But in accepting liability, you could then find yourself facing a prosecution based on your own admissions, which is quite a difficult pill to swallow. So that's what happened here, and they were fined a relatively small amount, I think, given the size of the organisation, £1,000. But the point is, they had 2 bites. The HSE had 2 bites of the cherry here. Publicly funded companies and hospitals and so on. So again, I've just given an example of a case where an NHS trust were prosecuted in respect of bedfalls that were known to be happening in a period of time, and they were prosecuted. They got a discount, but the judge's comments were all organisations, public or private, are accountable under criminal law. Public bodies will be held equally accountable, but they'll take into account the fact that it will have an impact on your ability to provide your services. And therefore, if they had been a private company, the NHS Trust would have been given a fine of £1 million, but reduced that accordingly by 50%. And then they got also another discount for the guilty plea. So it does happen. Now, I come to Tesco. Tesco have a couple of cases, and I just wanted to compare the difference in the way they were treated just after the guidelines came in and how they were dealt with a lot later. So a simple incident, and these are the two slipping incidents that I was able to find. The first one in relation to a slip of a member of staff who injured themselves on a leaking floor. Water was leaking on the shop floor, and this member of staff injured themselves. They were off work for several months. Tesco accordingly pleaded guilty. They recognised there was an issue, pleaded guilty to breaches of Health and Safety at Work Act, and also a failure to report, which is an odd charge. I've come across it a few times, but we also have to remember it is a criminal offence not to report accordingly, which is why we have to get our heads around the RIDDOR regulations and when you should and shouldn't report. But in this case, they were given a fine of 200,000. So again, this is just after the guidelines came in 2016 with some costs of 51,000. But the council were very keen to promote the idea that they are not going to hesitate to investigate large organisations in particular in respect of safety risk, particularly when we're dealing with members of the public. I think Tesco, unfortunately, were in a position at this moment in time, and it just so happens because they are a large organisation, it's likely they're going to fall foul of the law at some point. It just so happens they are one of many large organisations that often come before the courts for both environmental and health and safety breaches. But in this case, the council wanted to bring attention to the fact that there is a lot of importance placed on the risks posed to members of the public in particular, and they will go for the company. They will also go for individuals, but in this case, they didn't. Fast forward a few years later, and we get to a serious incident where a 91-year-old broke their hip, again, after falling, encountering while they were maneuvering their trolley, they came across a leakage from a refrigeration unit, and it wasn't only just the kind of liquid part, but it had been there for a while and congealed, and all of that added to the significant injury suffered by this member of the public. There were also issues that complaints were made by members of the staff beforehand about this leaking fridge unit, and there was no action by management, and this is really important, no action by management to take heed of those complaints. They did nothing about turning off the refrigeration units. They didn't close aisles. They didn't use barriers. So none of the preventative measures, or at least the mitigation measures, to mitigate the risk of a member of the public injuring themselves as a result of slipping. What in fact the staff were told to do was to put bits of cardboard down, but unfortunately that's another tripping hazard. Correct. So not quite the right approach. So Tesco were heavily criticised here, and if we were talking about that highly culpable, high culpability, seriousness of harm risk, the judge here said Tesco were highly culpable. I mean, this is absolutely unbelievably silly to not deal with this in a timely fashion. 2 months after staff had been complaining about the leakage. So Tesco had, I think, argued medium, but just wasn't going to wash. So highly culpable. They were given a very, very significant fine for breaches of Section 2 and 3 of the Health and Safety of Work Act of 733,000. So I think we're seeing here that for large organisations, they are not going to be dealt with softly, but also they are going to mention by name management's part in the breaches, and that comes up again when we talk about corporate manslaughter.
And just quickly on that example of Tesco and not picking on them specifically.
Yeah, I try not to.
No, but let's say Merlin had another similar issue as they had with the Smiler. Am I right in thinking that the fact that they'd had a previous fine for a similar incident is likely to mean that the next fine they would get would be higher? You know, or are they dealt with as standalone incidents?
No, it's used as an aggravating feature. I mean, a savvy prosecutor would simply get it in as bad character anyway if it was part of a trial, but certainly would be used to hike up the fine as a demonstration of previous.
So Tesco, that 733 fine might have been less had it not been for the previous one that they've had.
And it's the problem that they have consistently, because they have a number of these matters that keep coming up. And I think the argument is always going to be, you should know better. You've been in this situation before. And it's not just previous prosecutions or convictions. It's previous notices. It's previous interventions by a regulator. Anything like that can be used as an aggravating feature to hike up the fine. Just quickly dealing with individual culpability, it's the same approach. So you look at the culpability, you look at the seriousness of harm risk, and there's a matrix that's then generated in respect of the level of penalty. Just looking at this generally, you will see that there are very few options that avoid a custodial sentence for an individual that is successfully prosecuted. What you'll find is, for most directors though, particularly if they've never been in trouble before, they are likely to receive a custodial sentence, but it will be suspended for a period of time. Give them a period of time to ensure that they don't get into trouble again. And if they don't get into trouble for that period of time, they will never have to serve the custodial sentence. If they are lucky to avoid custody at all, it might well be that they receive a fine. And these are the levels of fines that can be imposed, obviously the worst being 600% of the individual's weekly income, which no matter what you earn, I still think that's a huge amount of money.
That's a lot of money, for a person,
For a person, and potentially may come out of their individual pocket, as we have to remember, insurance doesn't cover the criminal fines. What it may cover is your representation, so your legal representation. It may cover instructions of experts if you want to defend a case, but it won't cover the criminal fines, whether it's for the corporate or the individual. So it's really important from an individual perspective. I'm not going to go through all these individual cases, but what I will do is, I mean, you can just see from some of these the fines and the potential duty holders, individual duty holders held accountable. So in a very straightforward waste processing incident, companies fined a significant amount, engineer for this machine given immediate imprisonment because it's all about the locking mechanism not working, managing director given imprisonment, operations manager also given imprisonment, not suspended, because it was said that this was such an obvious risk that it should have been avoided. Again, I wanted to put this case in because this talks about former directors as opposed to active directors. So if you've got a company where the directors have come off, the statute, and they're no longer directors of the company, they could go back in respect of certain breaches. So in this case, it was exposure of asbestos. They went back and hauled the former directors into the dock in respect of their failure to manage the exposure of asbestos from a senior level. So pretty significant. And again, I've put this one in because we're not talking here about a limited company or the usual type of company we're talking about. Here, we're talking about trustees of a company. So we've got to remember the individual duty holders are not only directors, but it could well be governors, could be trustees, could be volunteers. I mean, it could be a number of different people, but it's looking at how the courts then will deal with those individuals. And as you'll see here, as much as the trustees were responsible for a near drowning of a child in respect of leisure facility activities, they were fined £10,000 each. Which is not a lot, but it is a lot if it's coming out of your own pocket. I certainly wouldn't want to do it.
No, exactly. Yeah.
And then just the last thing to talk about is corporate manslaughter. So again, the sentencing guidelines focus very heavily on health and safety. It also covers food safety, but more importantly, it covers corporate manslaughter. And the reason I bring this in is to think about senior management's role in potentially being a substantial element of a breach of a duty of care owed to someone who unfortunately dies as a result of that breach being committed. So it's all about the way in which a company manages its activities or organizes activities, and somehow the way in which that's been done has caused a person's death because of a breach of care owed to that person. And they look at a company's attitudes, practices, policies, systems, which is why I think it's so important to be proactive about looking at your existing policies and structure of the company and governance and leadership, because those are all the things that will tie in to assessing the level of culpability and risk when it comes to appointing a fine. And you can see here, levels of fines for the different sizes of organizations are much more significant than normal health and safety breaches. As you can see, the maximum fine for a top level offence for a large organisation is 20 million, which is huge. We haven't yet had a case of that nature, but I think we will when we deal with the Grenfell prosecutions. And as I said, the reputational issues are very important, even more so for corporate manslaughter, because there is also an opportunity for a court to publish the conviction, the particulars of the offence, the fine, and any remedial orders made. And what we've seen in some of these publications is some of the comments made by judges as well, which can be quite damning for those of you who are in industries that have relevant publications, because that's where this would go. It wouldn't go in the broadsheets necessarily, but it would go in industry publications that might affect your ability to trade or partner up with people. And then just one example of the case Bupa, which was probably a significant fine in a corporate manslaughter world, but straightforward issues. Risk assessment completed, but not really adhered to. And as many of us know, risk assessment offences often go hand in hand with any health and safety prosecution, because it's such an easy one to bring. We don't really know yet what a suitable and sufficient perfect risk assessment looks like. So it's very often you'll see that bandied about in a prosecution. So one of the first kind of £1 million fines for a kind of care provider that failed to deal with fire safety, not just health and safety duties. Okay, that's kind of what I wanted to cover. I know I did that quickly, and I hope that's either been a really good refresher for everybody, or if it's new to some of you, at least gives you some food for thought in respect of the things that you need to look out for. I have no idea if there are questions. I can stop sharing if you like.
There will be some questions. I'm going to ask you a few questions and then we'll open it up.
Okay,
there have been some questions. There have been some questions in the chat as well. Do you want to stop sharing and then?
Sorry. There you go.
Cool. So thank you for that. Firstly, that was really really useful. So I suppose for me, I'll just try and start with some broad questions, and then if anybody's got any specific questions, there have been some things in the chat, so people can feel free to either raise your hand. If you don't have to do that, go to reactions and then raise your hand virtually, and then I'll call you up to ask, or if not, then I'll pick some up in the chat box as well. So I suppose I'd be interested to know your insights on any kind of commonalities, either sort of positive or negative. So across the companies that you've worked with and supported, are there any areas where organizations kind of seem to often, if you excuse the pun, fall down on, or conversely, are there sort of areas where typically most organizations are doing pretty well? And then how does that kind of balance up with each other?
Okay, so dealing with where I think the commonality around failures or falling short, as I said, risk assessment always key, and it's about not just having a risk assessment, but ensuring that people are aware of it, understand it, it's implemented, reviewed, all of that. Those are the things that the regulators certainly look out for. The leadership and governance piece is also quite key. So it's not placing reliance on an active health and safety team or health and safety advisors, but to show that directors of companies and the board are taking accountability of how important health and safety is for the business, and that they demonstrate that. And there may well be a number of ways in which they demonstrate that, through the minutes of their meetings, or discussion, or engagement with staff, or engagement with the industry. But that's a very key criticism, is that you have a board that doesn't take health and safety seriously, doesn't demonstrate that well. And culture is a big one for most businesses. It's this idea that there isn't a proactive health and safety management culture, or that there's a lot of custom and practice issues. So people become complacent, particularly if you've got very experienced members of staff. What we're finding is experienced staff members tend to do things their own way sometimes. And that's where things can happen. I mean, we've had a very experienced groundworks engineer of 30 years who did a very silly thing and didn't adhere to sort of the mappings that were there, and identifying where the underground services were, took a breaker and just started digging and hit an underground cable. Now, if he had just gone through the very simple checks that most new starters would be aware of, that wouldn't have happened. But it was just the complacency and understanding, I know what this is, I know what I need to do, and I'm just going to go ahead and do it. So I mean, yeah, complacency is a big thing. So those are kind of some of the key things for failures. I think where people and businesses do really well is, on the flip side, you might have some companies that are very good in terms of the structure of the business, and they have either done very good audits, or whether that's internal or external, but they have an auditing system, or they have some sort of safety management system that makes health and safety compliance easier for the workforce. So I've seen that being a very convincing tool to the regulators. I've also seen as a convincing tool and a demonstration of good practice, having internal protocols, or a good incident response protocol, or good investigation techniques. That's also been an overwhelming factor, I think, in convincing a regulator not even to prosecute. If you can demonstrate those preventative measures, or the way in which you've investigated something and come out with an outcome that you may have had to share with other parties, has been useful, and it identifies the right risks, and it identifies the control measures. However, on this occasion something went wrong, it's not always going to be the case that you'll be prosecuted for it. It may well be that it can be dealt with in different ways. So I think if you've got these systems in place, and you've got good systems that most or all are aware of, that's a very good demonstration of anticipating risk, because that's where we are. We're in a risk-based environment. We're no longer in an injury based environment, which is where we used to be, where the mitigation would be someone didn't die. We can't say that anymore. We have to really be in a position where we say, as a business or as individuals in a significant capacity, we are anticipating risk, we are mitigating risk, we are controlling the risk, and that's where we have to be. So I think those are sort of the things that come up.
Yeah, no, that's great. And you mentioned there about maybe a bit of complacency at sort of board level, and drawing on that theme of we're now in a risk-based environment. I'm interested to know your thoughts on whether, since 2016, and particularly since COVID, where we all had to be doing dynamic risk assessments and risk became, such a big part of all of our lives, whether you've seen any improvement in that, or whether boards are a little bit more on the ball when it comes to safety and risk management now, or kind of have we perhaps peaked a bit during COVID and then perhaps lapsed off a bit since then?
That's an interesting question. I'm always amazed at the fact that people still tell me they're not aware of kind of the key issues in health and safety, or the risks to senior management, because many of us talk about this a lot, and perhaps we're still not reaching the right people. But there has been an improvement, certainly in the levels of compliance and the levels of awareness by boards in particular, because there are specific things that talk to boards. There are specific things that talk about management of health and safety at board level. There have been, the Institute of Directors guidance, which is now health and safety guidance, that leading health and safety from the top is a key example of the importance placed by boards on how to do this, how to do it. And that's the difficulty. It's all about, it's all well and good us talking about what you need to do, but it's the how you need to do it. And that's a very good example of how you can do it, that kind of plan, check, do that, circular environment. But there's also the idea that during COVID, I think more people had time to focus on risk, and they did so in a number of ways to varying success. I think now people have started to come back. I think largely most environments are back in person, or working in a hybrid way. I think what's been very, very good in the UK is our ability to adapt to different risk. And perhaps that is where the delay is in appreciating how to meet certain risks. So I think we've always been very good at understanding we need to look after employees. Now that they're working remotely or working everywhere else, that's made an employer's job more difficult. So it's being dynamic enough to understand that there are different ways in which you can meet those risks. And I think people are still going through that journey. I think we've done a great job so far. And in fact, prosecutions have gone down. Prosecutions have gone down for fatalities, and they've gone down for non-fatalities. We've seen the numbers rise pre-COVID to about 144 fatalities a year. It went down to 111 for a number of reasons. It went back up to 120 odd. So I mean, it's not too bad. Can always do better. And I think the ideas behind initiatives like Zero Harm and Target Zero, I think are well founded. I'm not sure we'll ever get there, but I think it's a really good goal to help us drive those figures down, and therefore the risk of prosecution goes down with that.
Yeah, good stuff. Natasha, you've got your hand up. Do you want to unmute and ask Kizzy a question?
Yes, why not? Hi, Christian. Hi, Kizzy.
Hi.
Just pricked my attention a bit. I was listening in, and you talked about the case where they'd been served notice and then was surprised when 3 months later were served with their papers for formal prosecution. Do you think that that's because people are not aware of it in business, of those sort of running businesses, of the enforcement management model in more detail? Because I think there's a significant issue with our industry and safety where we're not teaching people what it actually means and sort of managing it for them in a lot of ways. And we see a lot of that where we come across company directors and they might not understand that. They've just been told that they'll be, get a fine, a fee for intervention, as long as they fix it, everything will be fine. But in reality, that's just the enforcer's initial assessment and not their final assessment. And I think that process is lost in our industry a lot, where we're not communicating that to people or understanding it as professionals.
Yeah, it's such a good point. And I think perhaps I'm in an advantageous position in the sense that we have to look at things like EMM and so on, because it's part of our challenge. Part of our challenge towards the regulators is you haven't followed the enforcement management model. You haven't followed, prosecutors' code of conduct. You haven't. There's things that you shouldn't be doing. You should be making decisions. But even before that, I think it's extremely important to help businesses understand what those models and tests are, because it doesn't stop with an inspector coming along and identifying issues and then going away and serving you an invoice for their trouble. And I think, it's the lack of awareness that's been an issue, and maybe not even thinking they need to know at board level, because it isn't in their wheelhouse. It's actually, if we've got health and safety department, that's for them. And actually, that's not the case. We've moved so much from that, where we're in a position where it's everybody's responsibility, but particularly it's got to be led from the top. You've got to do that top down, bottom up filter, and it's not happening enough. So I think people do need to be aware. Hopefully, but through sessions like this and other sessions, people will become aware of the ability of a regulator to prosecute on the back of a notice being served, or even an informal visit. Because there's, to me, no such thing as an informal visit. Everything's a potential interview. So you've got to be aware. You've got to be aware of that.
Yeah, totally. I think it's for us safety professionals like we are, or others are in this session, it's about going out and remembering to dig into the detail of these things, not just assume that you know a bit about the sentencing guidelines, but actually there's stuff behind that
100%.
you know to advise other people.
100%. And also, just to add, safety advisors, you know, also need to be aware of this kind of trends towards individuals. You know, I think before a case I did in 2018 or 2014, but 2018 sentencing, there had been no significant prosecutions and convictions of safety advisors for Section 7 breaches. There are now. So it's worth looking at when we're looking at the move towards individual liability as well.
I can see a question in the chat from Jerry, which kind of follows up a little bit about this, which he put in the chat earlier, which was your point about challenging notices. Could you speak a bit about how to go about defending a prosecution after a served notice or an accident? Because obviously it's difficult to argue then that suitable systems were in place if you've had the notice.
If you've already accepted.
Yeah.
Well, it is very difficult. That's the point. So, I mean, there's no reason why you couldn't still defend, because don't forget, between service of notice, let's just say you don't challenge and you accept it. You're accepting it on the basis of whatever that notice says. It might well be the prosecution says something slightly different or expands on the reasons for prosecution, because don't forget, it does have to meet that test. It's not always that the notice content will meet the test of it being you know, having enough evidence to support the particular breach in question. So I think, yes, you can still challenge, but within a limited capacity if you haven't challenged the notice. From my perspective, I just think that back to Natasha's point, that awareness piece of what can happen will better inform businesses and individuals who are responsible for the response as to whether or not you should challenge. And it might be a very soft challenge. It might well be, we don't agree with the material breach that you have identified. However, we'll pay this notice because we want it complied with, but we don't want this to be taken as an admission of liability. That then holds your water if you are prosecuted, because you can then say, well, we never accepted liability. Why we paid it is because it's an invoice. Yeah, we paid it because it's an invoice. We didn't say we agreed. We didn't. I mean, and that's a very lawyerish thing to say, but I mean, there are ways in which you can softly challenge, A, without incurring lots of money, but B, protecting your position. And that's really where you want to be, to hold off if you need to challenge at a later date. So I'm not saying it's impossible, but it can be quite difficult if you've just blindly accepted whatever the prosecution say early on. Yeah.
No, that makes sense. I'm conscious of time, so I just want to share the next roundtable in a couple of weeks. So I deliberately chose this topic. We're going to be talking about so far as reasonably practicable discuss. So we won't be talking about it from a legal perspective. We'll be talking about it from a practical perspective. But that should be an interesting discussion for us all to have in a couple of weeks' time. So wrapping up then, Kizzy, thank you so much for your time and sharing your insights. I just wondered if there was anything you wanted to plug, like any upcoming events, or where's the best place for people to follow you and contact you? Is it just LinkedIn and so on and so forth? So the floor is yours to just finish off on that point.
I'm not very used to selling services. To be honest with you, I think for those of you who know me, you probably know I'm everywhere, but LinkedIn is a very good starting point. Safety and Health Expo, fire safety events, which are coming up in May. There's quite a lot. And if you are interested in kind of the legal aspect, but also the practical aspect, I think those expos are really, really good platforms to not only learn stuff, but network with your own people. And I'm sure if there are other things that I'm doing, in fact, tonight, if you are interested and you've got a construction background, I'm doing something for IIRSM. So that's a more legal update. So that's kind of what's happening in the last year or so. If you are interested in that, but by all means, please just keep spreading the message, I think, in the safety world, that we want to continue to be proactive and preventative. And we all want the same thing, but we come from
prolific.
And
proactive, preventive, and prolific. Because you and me have that in common. We're definitely prolific. So nobody could ever criticize us about not being prolific.
Definitely not, Christian. Definitely not.
Good stuff. Well, look, thank you very much, Kizzy. Really enjoyed it. Thanks everybody for joining. And see you again in a couple of weeks for the next session on the Safety Roundtable. Cheers.
Thanks, guys.
Bye.
Bye.
Thanks for joining us on the Safety and Risk Success podcast. If you've enjoyed this episode, please hit follow and do share on social media. Does anyone you know spring to mind as a great guest, even yourself? If so, please contact us on podcast@slipsafety.co.uk. See you next week for another episode.